Assalamualaikum warahmatullahi wabarakatuh, and a very good day to everyone, especially to our beloved Madam Sham. Today, our group 13, consists of me myself, Muhammad Afif bin ANWAR, Muhammad ARIFF AIMAN bin ABDUL HALIL, NAJMI ALIF bin ABDUL JABBAR, Muhammad HAZIQ bin Muhammad ZABIDI, and Muhammad SHAHRIL bin HAJA MOHAIDEEN. Will be presenting on the topic impact of Section 5 of Civil Law Act 1956 on the development of Malaysian law. So to start with, we know that most of the law practiced in Malaysia is based on the common English law system. So we can say that English law forms part of the law in Malaysia. Article 160 Clause 2 of the Federal Constitution states the definition of law, which includes the common law as far as it is in operation in the Federation or any part thereof that concern the extent to which the English law is applicable in Malaysia. Section 5 of the Civil Law Act is the application of English law in commercial matters such as corporations and business transactions. Nevertheless, the principle of Section 5 is same with Section 3 of the same Act, which allows the application of English commercial law if there is lacuna in any written law passed by Malaysian Parliament. So this is Section 5 of Civil Law Act 1956, where in subsection 1, it stated that all issues which arise or which have to be decided in the state of Peninsular Malaysia, other than Malacca and Penang, with respect to the law of commercial matters such as corporation and banks and banking, the law to be administered shall be the same as would be administered in England in the like case at the date of the coming into force of this Civil Law Act 1956. While in subsection 2, stated that all issues which arise in the state of Malacca, Penang, Sabah and Sarawak with the respect of the same commercial matter, like in subsection 1, the law to be administered shall be the same as would be administered in England in the like case at the corresponding period. If such question or issue had arisen or had to be decided in England, unless in any case other provision is or shall be made by any written law. So here is Section 3 of Civil Law Act 1956 that discuss the application of common law of England and the rules of equity and in prescribed circumstances English statutes that can be used in Malaysia if there is a lacuna in written law passed by Malaysian Parliament. Next, I will pass to the next presenter.
Sections 3 and 5 of the Civil Law Act are provisions that allow for the application of English law in Malaysia, and many have debated over whether these provisions have actually brought positive or negative impact to our legal system. Section 5 governs the application of the English law in Malaysia for commercial matters and applies when lacuna appears in commercial matters. The introduction of this law saw all Malaysian states be allowed to apply English law with the cut-off date of 7 April 1956, except for certain states, such as Malacca, Penang, Sabah and Sarawak, which are allowed to apply the English law for commercial matters without any cut-off dates. This term used in this provision, that the law administered shall be the same as in England, allows and provides for a wider application of the English law, as it does not limit or place any barriers over which English laws are the only ones to be allowed and applied. Chief Justice Tun Ahmad Fairuz echoes the views of the late Prof. Ahmad Ibrahim, who was a strong advocate of developing our own Malaysian common law, which would reduce the power and significance of the English law in Malaysia, as he once questioned whether Malaysia lacked the legal expertise to apply the CLA entirely instead of creating our own system. This is based on the notion that the English law is being applied without any amendments suited to the Malaysian context. However, one may even argue that the spirit of the English law doesn't exist just by the CLA itself, but also through other acts that are enacted or adapted from the English law. Not applying English law in Malaysia to compensate for the shortcomings of the law will result in a large unfilled void of uncertainty towards certain matters. Param Kumaraswamy, a former UN Special Rapporteur, stated that common law principles as applied and developed in England would still be better off still received and accepted in Malaysia to accommodate for the lack of express or domestic laws on certain specific matters. Chief Justice Tun Arifin Zakaria in 2017 had clarified that the common law principle that we apply today is not outdated or antiquated as claimed by Chief Justice Tun Ahmad Fairuz, as it still satisfies the needs of the Malaysian law. Laws can always evolve per amendments and current developments, so it keeps up to date with the ever-changing needs of the Malaysian society. The removal or not applying common law when there is lacuna will only result in detriment to society, as we are not equipped with enough alternatives to the common law when regarding non-existent provisions.
The case where Section 5 of the Civil Law Act 1956 can be seen is the case of Nur Azlan binti Razali, Ed Abdurazi, and Kamunri bin Nahu and others. The plaintiff is the sole registered owner of a parcel of land situated in Tawau, Sabah. It is subject of matter dispute in the case at hand. The plaintiff's cause of action lies in trespass. She complained that they had constructed dwellings thereon and continued to commit trespass. The original owner of the land was Amasain bin Namong. According to the defendant's record, the defendants bought land from Amasain. Amasain died on January 12, 2005, leaving no will. Amasain then appointed the defendant as the attorney for the estate. The appointment of the attorney will give the respondent title to land for the purpose of clearing and cultivating the land in question with the approval of the government, signing on behalf of the sponsor, and request a draft of the title or title itself to develop, sell and transfer the land in question, request and authorized to amend special conditions. All the defendants claim that they had been occupying the subject land since 1998 and with the authority. After Amasain passed away on January 12, 2005, his son Muhammad Ed Ribut bin Amasain became the administrator of his estate by an order of the Mahkamah Tinggi Syariah Tawau. According to the distribution decree issued by Mahkamah Tinggi Syariah Tawau on November 19, 2015, the following children of Amasain became owners of the land in proportion to which Ribut and Kurus Misain received 2/5 shares portion of the land, while Udang binti Amasain takes 1/5 of the action. They offered to sell the land to the plaintiff for 60,000 ringgit. In compliance with the special terms stated in the title deed, the prior written consent of the Director of Land and Surveys was obtained via the letter dated 22 August 2016. The registered owners and the plaintiff signed the memorandum of transfer dated 1 September 2016 upon payment of the purchase price. In this case, the question for the judge is whether the appointment of the prosecutor to resolve the land issue will remain in effect after the death of the donor. It will be recalled that Amasain, the donor, died on January 12, 2005. The defendants forced to invoke the power of attorney in this case. There is no state law wholly and specifically dedicated to powers of attorney in Sabah. Although they are expressly mentioned and regulated to a limited extent under Section 64, Clause 2 and 98 of the Law Ordinance, both of which are of no relevance in determining the question whether the appointment of the attorney survived the death of Amasain. The defendant in this case held that the English law can be used under the provision of Attorney Act 1971 in the state of Sabah by virtue of the provisions of Section 5 Clause 1 and 2 of the Civil Law Act 1956. On the other hand, the provision only applies unless in any case other provision is or shall be made by any written law, as stated in Section 5 Clause 2 of the Civil Law Act 1956. The presence of Malaysian Contracts Act 1950, which has an entire chapter on agency, would apply to powers of attorney in Sabah, and it is also mentioned in Sections 64 Clause 2 and 98 of the Sabah Land Ordinance. Thus, the said powers of Attorney Act 1971 does not apply to Sabah. Thus, in this case, the defendant's claim to rely on English law is not valid. It can be seen that Section 5 of the Civil Law Act 1956 is applicable only to some extent, and the local law will always prevail. Thank you.
Now, we will moving on to the findings and application of Section 5 of Civil Law Act 1956 on the development of Malaysian law. For the findings, we found out that Section 5 of the Civil Law Act is the application of English law in commercial matters such as insurance and business transaction. Reception of English law, whether common law or statutory law, to the subjects mentioned is limited to the laws as they existed on 7 April 1956 when the Act civil effect. common laws or laws written after the cut-off date do not automatically apply. Applied that in the Malaysian court, the use of English law cannot be implied if there exists statutory provision in Malaysian law, unless there are lacuna in our law. A related point to note is the cut-off dates: 7 April 1956 for West Malaysia, December 1st 1951 for Sabah, and December 12, 1949 for Sarawak. Common law principles apply and develop in the United Kingdom and other Commonwealth countries should continue to be adopted and applied in Malaysia, whether there is no clear national law or to deal with the problem, loopholes or ambiguities in the law. The Malaysian court itself is structured around common law's values. Abandon common law or leaving it out could damage the basic structure of the constitution. According to Malaysian Bar Council, there are two ways in applying the Section 5 of Civil Law Act 1956 in Malaysia. The first method are, in all matters which arise or need to be decided in the western states of Malaysia, other than Malacca and Penang, concerning the law of partnerships, corporations, banks, principals and agents, carries air, land and sea freight, marriage insurance, average insurance, life insurance and fire insurance, and with respect to general commercial law, the applicable law will be the same as that which will apply in the United Kingdom, in a like manner of the date of entry into force of this Act. If any such question or matter has arisen or needs to be decided in England, unless in any case some other provision does not apply or is not provided for by the written law. The second matters are, in any question which arises or needs to be decided in the states of Malacca, Penang, Sabah and Sarawak on law relating to any matters referred to in subsection 1, the law should prevail. It will be similar to that which will be administered in England in the same circumstances in the respective period, if such a question or matter had arisen or had to be decided in England, unless in any case in any event some other provision is or is provided for by a written law.
Conclusion. Malaysia is yet to develop the statute under Section 5 of the Civil Law Act as well as its neighbouring country, Singapore, as Malaysia has been operated purely by the Constitution as the consequence of the government efforts on the English commercial legislation on Malaysia's coverage. Malaysia has also eliminated the laws under European Union law, as the rules under Malaysia are expressly employed and have been enforced here since the colonial powers occupied Malaysia before its independence. With their original regulation has been altered to ensure better changes, partly had been applied here in West Malaysia, while East Malaysia, such as Sarawak, has long been in comfort of modification under Section 3, Clause 2 of Civil Law Act. Malaysia also enjoys an immense clarity and certainty as the pre-independence of United Kingdom legislation be applied in Malaysia as a result of identification by Singapore of the colonial commercial legislation in the schedule of its application of English Law Act, as it also spells out Sarawak out from the provisions applied.